Right, everyone, as I was describing, we've had a few IT difficulties which hopefully have been fixed through the ingenuity of my good friend, colleague and co-presenter Geraint Probert here, who has ingeniously logged in and is hopefully sharing the slides with you. I understand that is in fact the case, and hopefully also you can hear us. Now, today we are embarking upon a breakfast bites which has, if we move to the next slide, please. Sure. This is so old-fashioned. We have 5 cases to look at today, and also Geraint's going to tell us about the neutral citation of EAT judgments. I'm going to deal with the first 3, starting with Smith and Pimlico Plumbers, the reprise, then moving on to the next case of Shitu versus South London and Maudsley NHS Foundation Trust, and then the case of Bennett and Mytac Europe Limited, which is of particular interest for all aspects of the discrimination jurisdiction. And then Geraint's going to look at Coker and Angard Staffing Solutions Limited and Byrne versus Alder-Hay Children's NHS Foundation Trust. Next slide, please. So we start off this morning with probably the biggest news in our world for some time, the outcome of the Court of Appeal decision in Smith and Pimlico Plumbers number 2. Now, I noticed when I was looking at this over the weekend that in fact it hasn't yet been officially designated number 2, but I think for our intents and purposes it's distinct from the number 1, which was, you can see from the slide, the Smith and Pimlico Plumbers case that we all know and love in relation to worker status. As we know, in 2018, just to refresh our memories, the Supreme Court determined worker status in Mr. Smith's favour following years of litigation against Pimlico Plumbers. And one would have thought then that given that he was a worker, that he was entitled to 5.6 weeks paid leave, which usually is the case in these circumstances, and that he would have thought that the rest of it would have been, as a colleague of mine might have said, all gravy. But unfortunately it wasn't. How hard can it be to get paid out for your holiday pay, particularly when you've gone to the Supreme Court and the Court of Justice, Well, the Supreme Court rather. One never knows these things. As we can see on the 3rd point on the slide, back in the Employment Tribunal, he had his claim rejected because the other side, Pimlico Plumbers, rightfully, as we can see from subsequent slides, took a pleading point that he had not pleaded a case for holiday accrued but not taken to the end of the engagement in 2011. He only had submitted a claim for non-payment of wages for leave actually taken in each year of engagement, which had been submitted out of time. And it was submitted on Mr. Smith's behalf, as we can see from the end of the slide, that the case of King versus Sash Window Workshop, well-known case in our field, particularly given the Court of Justice determination in respect of that, had indicated that it permitted a claim on termination for all unpaid annual leave, whether untaken or not, or whether taken or not, in circumstances where the employer had not permitted that leave to take place. The archetypal case being that, as in the King case, but also the parallel analogy in this case, where the employer had not recognized that the worker was in fact a worker, thereby not offering remunerated annual leave. So, having been incredibly disappointed in the Employment Tribunal, as one might have expected given the length of the litigation, particularly to be undone on a pleading point, he went to the Employment Appeal Tribunal, where he met with a similar level of a lack of success. His King argument was considered by the President, as he was then, Mr. Justice Chowdhury, who had held that the case of King was not concerned with leave that was taken but unpaid. It concerned the right to carry over until termination leave that is not taken because of a failure to remunerate that leave. So it did not concern a right to carry over leave that is taken but not remunerated, which seems like a very pernickety point of distinction, but it's one that Mr. Justice Chowdhury was persuaded by in the EAT, and the EAT also upheld the the decision in order to add effective insult to further injury to Mr. Smith, that the tribunal had correctly construed the pleaded claims, notwithstanding the arguments that were put that king and sash windows had meant that they should be considered and construed in a way that is sympathetic to the working time directive. We move on. So the matter came before the Court of Appeal, fully argued appeal, as we know, and there are four main grounds of appeal, but Lady Justice Simler distilled them into three main issues for determination, and you can see them on the slide in front of us. Firstly, did the Employment Tribunal and the Employment Appeal Tribunal err in holding that Mr. Smith's only pleaded claim was for pay for the holiday leave he actually took without pay during his engagement with Pimlico Plumbers? Secondly, what is the scope of king, and do its principles mean that someone in Mr. Smith's position was entitled to carry over and accumulate his entitlement to paid annual leave until his engagement was terminated? And thirdly, is the series of deductions within the meaning of Section 23(3)(a) of the Employment Rights Act 1996 broken by a gap of 3 months or more, the bare Scotland point, as we know and love? And in terms of each of those points, next slide, please. The Lady Justice Simler was persuaded that the Employment Tribunal EAT had correctly considered the pleading point that had been put before it. The claim had not encompassed a Regulation 14 working time payment claim for payment in lieu of leave not taken at the date of termination, which is somewhat surprising given the fact that this is a problem that he had in relation to this point forensically, that the matter had been pleaded by his solicitors, but they had made repeated references in subsequent documents to Regulations 13 and 16 that had not mentioned Regulation 14. And it didn't, in terms in the claim form, which was the crucial document, identify that he was refused or otherwise did not take his full entitlement of 4 weeks leave each year, such that he was entitled to payment on termination under Regulation 14 as a payment in lieu on termination, or words to that effect. So on the papers in front of the Court of Appeal, they accepted the argument put forward by the Employment Tribunal that the Regulation 14 claim had not been put. So therefore, it was a claim which related to the relevant leave years, which were out of time. But in terms of the point that was made by way of a submission based upon the case of King, it was held that if the effect of King was such that the matter should be construed in a manner sympathetic to Article 7, the Working Time Directive, and indeed the rights that accrue under the Charter of Fundamental Rights, then one would think that perhaps one could look at the pleading more sympathetically and take the view that, in fact, what there was that it should have been viewed as a claim based upon a single right to paid leave, which is denied by the respondent because it refused to remunerate, which should be viewed as being inherent within the claim form, and such that the matter should be interpreted in a more, well, effectively holistic way. Next slide, please. The second and probably the most important point in the appeal, though, was what is the scope of King, and do its principles mean that someone in Mr. Smith's position was entitled to carry over and accumulate his entitlement to paid annual leave until his engagement was terminated? Now, significantly, King was held to be based on broader principles of European law, derived from the Working Time Directive, but also from the Article 31(2) of the Charter, which, notwithstanding Brexit, form part of the retained law, at least in principle, as matters presently stand. So the King principles carry through. As such, there is no precondition to be attached to the right to paid annual leave that a worker has requested and been refused annual leave. Moreover, it was suggested that any construction of Regulation 30 of the Working Time Regulations, whereby it might be suggested that in circumstances where a worker is denied his right to paid annual leave in some respect or discouraged from taking so, any rules that would prevent the accumulation or carryover of that right in such circumstances would be incompatible with the Working Time Directive and thus should not be upheld. But the most crucial point here, and this is the emphasis which is placed on the third point on the slide, is that the right to paid annual leave is not a right which is two rights, i.e. you have a right to paid annual leave and then you have a right to be effectively reimbursed your remuneration thereafter. It's a single composite right. You should have a right to paid annual leave. It is very much a Ron Seal sort of right. It does what it says on the tin. And so you must have the benefit and the peace of mind that goes with having that annual leave at the same time. And you'll note in the submissions and indeed the judgment that significant emphasis was placed by the Court of Appeal on the health and safety aspect of working time of annual leave, and that the single composite right is the approach which is most consistent with that. Next slide, please. So where does this leave us then on this point? It leaves us on the point that, as you can see, a worker can only carry over and accumulate a claim for payment in lieu on termination. The worker is prevented from exercising the right to unpaid annual leave and does not take some or all of his leave entitlement or takes unpaid leave for reasons beyond his control because the employer refused to recognize the right and remunerate annual leave. So if you're a worker and you are subsequently held to be a worker, and in the meantime you have taken unpaid annual leave, either in whole or indeed in part of what would otherwise be your usual entitlement under the under what we call EU holiday pay, that or EU annual leave, that would entitle you to be paid. You should be entitled to be paid the rest upon a claim. Moreover, given the interpretation that King provides, where you are prevented from taking leave in the relevant leave year, one effectively reads in to the Working Time Regulations that if a claim is made within 3 months of termination, it will be in time, paragraph 87. And importantly, the Court of Appeal endorsed the cases of Shimizu, Kreuziger, and Bauer, where the burden is on the employer to show all due diligence in respecting the composite right, which involves effectively, if one looks at Shimizu and Kreuziger, effectively encouraging or otherwise signposting the right to paid annual leave, and also to be able to evidence that through proper record keeping. So these are all important rights which are now being brought into domestic law. The third point didn't really need to be decided after the second point was decided in favor of Mr. Smith. But nonetheless, the Court of Appeal went on to consider it because there is conflicting authority. The Bear Scotland case in the EAT versus Agnew in the Northern Ireland Court of Appeal. So this matter is strictly obiter, but it was nevertheless expressed as a strong provisional view that Agnew should be preferred. So whereas we had the comfort of somewhat of the certainty, albeit fairly harsh certainty, of a Bear Scotland, that a series of deductions can be broken by a gap of 3 months or more, the preferred route for the Court of Appeal, at least on a strong provisional view, is that there is nothing in Section 23(3)A that prescribes such a rigid approach, that effectively a series is a matter of fact and degree, and it can be 3 months, it can be more than 3 months, it can be less than 3 months. But what matters is the identification of a sufficient factual and temporal link between the chains, or links indeed, in that particular series. It's also suggested, of course, you'll bear in mind the 2-year backstop in respect of a series of deduction claims presented after the 1st of July 2015. One might think actually in cases similar to that of Mr. Smith that effectively it's been bypassed by the decision in respect of the King case, because effectively you can continue to bring that claim, and it would effectively amount to provision that would otherwise prevent or hinder an effective remedy in respect of a working time directive right under Article 7. So that's that. Next slide, please, Geraint. And as is customary these days in cases of this sort, there's an extremely exciting appendix to the judgment, because you'll remember NHS Leeds and Larner, where they were, and Duncan and the Duncan Print Group and Plum, where the where subsequent appellate courts have written in effective notes, or rather common law notes onto the existing statutory or regulatory framework. Well, this judgment is no different. We have a new regulation 1316, effectively, which has been imposed by common law, which is set out in red below, which some on the slide in front of you, which sets out the effect of the judgment in this case of Smith and Pimlico Plumbers. And I'll just read it out for the sake of the record. 16, where in any leave year an employer, 1, fails to recognise a worker's right to paid annual leave, and 2, cannot show that it provides a facility for taking of such leave, the worker shall be entitled to carry forward any leave which is taken but unpaid and or which is not taken into subsequent leave years. So there we have it, as clear an exposition of the European law sympathetic approach to working time and annual leave. So what are the learning points arising out of this particular case? Well, firstly, don't count your chickens when you come back from the Supreme Court upon remission, and indeed watch out for pleading points even in effectively year 8 or year 9 of the litigation. That's tough. And as we can see there, precision in pleadings do matter. Another factor which counted against this was also the lack of a timely amendment application as well, to actually bring in the regulation 14 point. So in cases such as this, it's probably good to cover off regulation 13, 14 and 16 plus the enforcement section of regulation 30. Secondly, Bear Scotland's a dead stick. It's highly unlikely to survive any future serious appellate scrutiny given the strong provisional view expressed by the Court of Appeal in Smith. There's the imposition of the new effectively transposition of the European law position in domestic law, that there is a burden on the employer to prove all due diligence in order to enable the worker to take paid annual leave to which he's entitled. See paragraph 82 of the judgment, because plainly that emphasizes the need for proper record keeping and proper signposting of leave. One simply cannot rely upon the ignorance of an employee anymore in relation to them not being entitled to rights under the working time regulations. One has to do more as an employer and to forensically be in a position to evidence that should a claim arise. The final point arising is with respect to Brexit. Obviously, the rights which have been carried through and expressed within the Court of Appeal judgment are retained rights under the Withdrawal Act. Of course, things could change if there was an amendment to the working time regulations, but as matters presently stand, this is all good law, at least for now. So that's Smith and Pimlico Plumbers. Hopefully that makes sense. We now move on to a completely different area of law, the case of Shittu and South London and Maudsley NHS Foundation Trust. Now, this is an interesting case, not because so much of what happened below, but what happened in relation to remedy. Now, I think we've all had these sorts of cases where a claimant, whether you're acting for the claimant or the respondent, but nevertheless, there are a large number of different claims that are brought by a claimant, encompassing the usual range of whistleblowing detriments, detriments arising out of having made protected acts, a suite of disability discrimination claims, as well as usual bullying and harassment and constructive dismissal, all being wrapped up in a melange of claims. And that's exactly what faced the parties in the Shitu case. The large number of claims, claimant had a limited degree of success at the employment tribunal in respect to the claims of constructive dismissal and discriminatory dismissal. Effectively, only one factual allegation was the result of material success, that in that case, the respondent had failed to investigate and deal with claimant's complaint about being subjected to an unlawful deduction of 1 day's pay when he had been absent from work at a hospital appointment for a post-cancer checkup and colonoscopy, which was held to be a breach of the implied term of trust and confidence. And thus, as the claimant had resigned partly in response to that, but also in response to a whole host of other things which weren't found to be liable, but partly in response to that constructive dismissal was made out, there being no fair reason pleaded in the alternative. And the treatment, which was a deduction of pay for a cancer-related checkup and a failure to investigate and deal with the complaint, was found to result to both discrimination arising from disability and also a failure to make reasonable adjustments. So within that one incident, which the employer had failed upon, was the entire core of the finding of liability. Not surprisingly, when one gets to the position of remedy, which is why this matter went to appeal, the claimant was relatively unsuccessful. He was awarded a basic award of just under £6,000, lost statutory rights, injury to feelings of £5,000, and interest, making a total of £12,245.26. Let's not forget, it was a massive claim described by the judge as Herculean for the task of the tribunal, and the remedy hearing itself took 5 days. But 12 grand and a bit was the outcome of that. The claimant appealed. He certainly, particularly because he had not been awarded compensation or damages for loss of earnings. The key point here is that the tribunal considered each of the strands of causation arising out of what had been a reason for dismissal, constructive dismissal, and sort of discrimination, and what hadn't been, and found and made a key finding: claimant would have resigned anyway as a result of the myriad of other matters that were in play, which had not been upheld, as well as there being a cogent medical evidence about his psychiatric health, which indicated that there was a clear direction of travel. Thank you, Geraint, for the next slide. Now, this is interesting because, firstly, the key question is, did the employment tribunal assess compensation on balanced probabilities basis or loss of the chance? Because it was such a stark decision, the 100%, it might have been said that it might have been approached by way of a loss of a chance, i.e. an all or nothing approach, or was it approached as 100% or 0% based upon a percentage assessment approach? In real terms, no real difference, but in forensic terms, a matter of considerable importance of principle. The first point that to draw out of the judgment, which is why I brought it to your attention this lovely late February morning, is the fact that firstly, the approach to the assessment of compensation in discrimination unfair dismissal claims will be materially identical, notwithstanding the slightly different wording of the two respective parts of the Employment Rights Act and the Equality Act. Secondly, the point I was making earlier, where there are some reasons for resignation which are found to be a matter of liability and some which are not, one has to, if you're the tribunal, identify those losses that flow from the culpable parts and not the bits that were not liable. It was also held, based upon an analysis, a close reading of the judgment, that the tribunal had correctly adopted the loss of a chance approach, which was the assessment of the prospect of resignation due to some other non-liability reasons. Next slide, please, Geraint. So that should have determined matters, but the tribunal went on because it had heard full argument in respect of the case in the Supreme Court of Perry versus Rowley Solicitors, a professional negligence case, as to whether or not, in cases of constructive dismissal, whether or not, given the fact that the decision to resign is in the hands of the claimant alone and not necessarily referable to the acts of third parties, that one should adopt a different approach more akin to that in a professional negligence case, whereby you look at it in terms of what the claimant would have done on a balanced probabilities basis. And if there's a third party involved, then you look at it on a loss of a chance basis. So that was the effective question. The tribunal said no, we're not going to be doing that, notwithstanding the Supreme Court decision. There are only three basic questions in these circumstances, and they're set out on the slide in front of you. Was the loss occasioned as a consequence of dismissal? Was the loss attributable to the conduct of the employer? And if so, was it just and equitable to award compensation? That's effectively what the tribunal is being asked, whether it's discrimination, whether it's unfair dismissal. Now, as in this case, 100% deduction or a 0% outcome will be effectively the same in result to a balanced probabilities approach. Nonetheless, it can be arrived at legitimately through loss of a chance assessment. And importantly, what was suggested is that the principles in professional negligence cases, Perry and Rayleigh, will not apply in the employment arena. There are 50 years of decided cases where the loss of a chance approach is appropriate. The relationship in professional negligence cases, it was emphasized, is very different to that within a workplace and the employment sphere. It's a transactional arrangement effectively in professional negligence, whereas it is a wider set of rights and relationships which require a more holistic, again, the second time today I've used that approach and word. Right. So helpfully, this case also indicated, and relying heavily upon Software 2000 and Andrews, a well-known case from, I think, the last decade, 2007 IRLR 568. There are effectively four main outcomes, although obviously the tribunals have wide discretion to top and tail the outcomes that they see fit. And I've set them out on the slide. Either there's a less than 100% chance of indefinite continued employment, in which the tribunal must assess the percentage chance and apply that percentage reduction. If the tribunal is satisfied in the evidence there's a 100% chance employment would have ended anyway by a certain time or at the same time as the dismissal, the claimant is awarded 100%, whatever that period is, or nil if it was the same date as dismissal. If the employment would have continued indefinitely, there's no reduction, and there's a 100% chance employment would have continued a certain period, followed by a lesser percentage chance, effectively a tapering off approach. Tribunals could do that. And in fact, as I said, tribunals can adopt a range of approaches as long as they are principled and legitimate effectively. Next slide, please. My third case, before I hand over to Geraint this morning, I hope that clock is right. Yes, it is. Good. Is a very exciting case because it is the first reported case of one of our most junior members of the team, which is Anna Williams. And so this is the case of Bennett and Mitak Europe Limited, 2022 IRLR 25. I should emphasize that's not the reason why I picked this case out for reading. It's actually a really useful case. It's another one of those useful judgments from His Honor Judge Taylor, who sets out and goes to great trouble to set out in helpful and I say respectfully clear and precise ways. He sets out principles in a very helpful way for practitioners, and his judgments should be, I commend to you, and this is one of them. Now, in this case, this is a rare claim of associative discrimination, effectively where, in this case, the responding company was the European subsidiary of the Mitak Group, which is a Taiwanese entity. And someone called, we'll refer to him as Mr. B, was recruited as a UK sales and marketing director soon after the claimant was recruited as his line report as the sales manager. Unfortunately, Mr. B was diagnosed with cancer, and he told his boss, the European business head in Amsterdam, that he expected to have one of his kidneys removed and that he'd require dialysis. He subsequently received a firm diagnosis of cancer. He informed the respondent, and subsequently a meeting was fixed for his operation. In the meantime, management in Taiwan had been concerned about the performance of the European, and particularly the UK business, and they thought about dismissing some or all of the UK team quite separately. Now, whilst there were concerns about Mr. B and the claimant's performance, she nevertheless, their manager in Europe, Ms. Huang, recommended that they should pass their probation periods. Subsequently, though, in late August, the decision was taken, this is August 18, decision was taken to close part of the business, which resulted in the loss of positions held by Mr. B and the claimant. Then, in the topsy-turvy world of business, of course, businesses started to look up again. Business prospects for the entity in Europe, particularly in Britain, looked up, and it's proposed they'd be retained. However, at the beginning of September 18, following an email from the global president in Taiwan, Mr. Chang, Mr. B and the claimant were dismissed, and Mr. B asserted he was being pushed out of the business because of his cancer. The claimant therefore brought a claim of associated discrimination because he was being pushed out because his boss was being pushed out because of his cancer. Now, a key aspect of this is that the decision maker here did not give evidence before the employment tribunal, and notwithstanding that, the respondent succeeded on the basis of the tribunal's analysis, fundamentally, of the contemporaneous documentary evidence and other circumstantial evidence, which was potentially problematic. And so that, as it's indicated at the end of the slide, the tribunal found that claimant was dismissed because of his own poor performance, not the association with his colleague. Next slide, please, Geraint. So this case is interesting because, firstly, it sets out in brief where associated discrimination claims arise. Because, we tend to try to put these sorts of things to the back of our mind, but actually they could be more prevalent than we think. Firstly, the main categories are where care and responsibilities for persons with protected characteristics such as disability arise. That's the Coleman and Attridge situation. Then there's the refusal of an instruction to discriminate, and then there's detrimental treatment because it is thought that a person possesses a protected characteristic. These are all effectively associated discrimination types of claim. But the key point is at the bottom of the slide, which is it's not about labeling, it's not about categories, it's about whether the protected characteristic of another person was an effective cause of the treatment of the claimant. That's where it arises. Next slide, please, Geraint. The other thing that's interesting is the analysis of comparators, particularly in discrimination cases, because it was emphasized the relevant circumstances in such cases include a person's abilities. So in direct discrimination claims, it's necessary to compare the treatment of the claimant with an actual hypothetical person with comparable abilities. In such circumstances, it may well lead to a situation which commonplace that direct discrimination may not be the way forward, because if you compare like with like in such circumstances, it's more about the effect of the disability, the underlying effect of disability, which makes it a Section 15 claim as a Section 13 claim. Obviously, not a useful jumping off point for an associated discrimination claim, which are based upon Section 13 cases. However, and this is where the tribunal also potentially fell into error in this case, if you make stereotypical assumptions about a person's ability or future ability, particularly if they're disabled, this can amount to direct discrimination. So if you assume, for instance, they'll have poor attendance in the future because of their disability, or you think that's the way it's going to pan out without any evidence or otherwise, that will potentially move the needle from Section 15 to Section 13. And that's an interesting point in my view. Next slide, please, Geraint. Then we have a particularly big slide, which I won't read through all of it, but the point is that it's a very helpful slide because it tries to précis the guidance given by His Honour Judge Taylor on a phobia, and in particular what happens where a respondent has to discharge the Section 136 burden, particularly where the decision maker isn't called. And just to make a long story short, one needs to focus upon the need for cogent evidence, because where the respondent is being asked to discharge the burden of proof, one must always bear in mind the respondent is in the position of being able to deploy the evidence that they wish to choose. So if the respondent doesn't call the decision maker, the tribunal should really scratch its head and dig down into that particular point, because one would have to think, well, why haven't they? And is it right that the tribunal can decide the matter on the basis of documentary evidence? Now, whilst it's possible to do so, In the absence of the decision maker, one would need compelling in documentary evidence to do so. And moreover, the tribunal will need to set out a clear and careful analysis of why it has decided, notwithstanding the absence of the core evidence, that being the decision maker, witness evidence, why it is that the decision maker has not been called. And it may well be they form the view the decision maker is a loose cannon, in which case, well, that's a good reason again to not accept the respondent's explanation on that particular point. But you have the slide. It's quite a meaty slide, which we don't have time to go through in any more detail. Finally, there's the question about relevance to the date of the diagnosis of disability. The tribunal had adopted the approach that any evidence about the decision maker's attitude to the claimant could only be relevant once they acknowledged that ill health constituted disability. Now, the tribunal focused on the date of the diagnosis. That's wrong. The approach under Section 6, under Paragraph 6, Schedule 1, is all about effectively the existence of a disability as opposed to the notion of when it's medically diagnosed. That is evidence. That can go to how long the disability has been in play. That goes to the question of knowledge. But what it does not do is it doesn't supplant the actual need to look at the statutory wording and carry out the necessary analysis. So that's my section. I've run over slightly. I apologize to Geraint, and I hand you over to the dulcet tones of my good colleague Geraint, who sat here, who will control his own slides.
Yeah, wow, the power of being able to control your own slides. Okay, thanks everyone. I'm going to look briefly at this case of Cocker, which is all about the Agency Workers Regulations 2010. And of course, they are derived in terms from the European Directive from 2008. That was important in terms of this decision. But let me just give you the quick background. This is all about Regulation 13.1 of the AWR, whereas this principle was in play, that an agency worker has, during an assignment with a third party, the right to be informed by the hirer, that third party, of any relevant vacant posts within the hirer. This is stated as to give the agency worker the same opportunity as a comparable worker to find permanent employment with the hirer. So just to make it clear, you have an agency worker who is employed directly by an agency and then go off and work for a hirer. That third party, we're calling them the hirer. Under the AWR, there are certain circumstances where the agency worker has rights to be treated in a similar or same way as a permanent worker would who is employed by the hirer. So quite a potentially broad-ranging right there. But how far does it stretch? Well, here are the facts. The claimant was employed by Angard. That was an agency that was wholly owned by Royal Mail. And Angard provided agency workers to Royal Mail as and when Royal Mail needed it, as it turned out, pretty frequently, as the fluctuating need for postal workers arose. The claimant worked at the Leeds Mail Centre and had been working there for a little while. And the practice was, within that centre, was for vacancies for Royal Mail positions to be put on a notice board. Quite old-fashioned when you think about it, but it was put there on a notice board. And in terms of the priority for those particular permanent posts, it went in this order. First of all, internal permanent post holders were number one in terms of priority for applying for those internal jobs. The second class then was what was called the reserve class. So persons who weren't on permanent employment, but were nevertheless employed by Royal Mail, they had second bite of the cherry. But agency workers, like the claimant, were not eligible to apply for those internal posts, but they were eligible to apply for anything that was advertised externally to the wide employment labour market, and essentially they would be on exactly the same footing as any other external applicant for those posts. Of course, there were plenty of internal roles that were only ever advertised internally. They never got to the external stage. And so the argument from the claimant was, hang on, I'm not being treated in the same way, Regulation 13.1, as a permanent employee of the hirer, because I'm not allowed to apply for those roles. So essentially what the claimant's submission was that it broke down into three parts, which are there on the slide. the right to be notified of the vacancies, the right to apply for those vacancies, and then the right to be considered. And you can see how each of those actually needs to sew together to come up with some sort of argument for the claimant, because even if he was notified of the vacancies on the notice board, well, that's no good to him if he can't apply for them. And it's no good being able to apply for them if your application isn't going to be considered. So those three things were necessary on the part of his submission. Now, under the Employment Tribunal's judgment at the first instance, they construed Article 13.1 as being an express right to receive information, and that extended to an implicit right to apply for relevant vacant posts. That makes sense from a logical, progressive point of view. But the EAT disagreed. Their interpretation was that this was far narrower under Regulation 13.1, that it was only the right to be notified of the vacancies, to have the same level of information, so parity of information with the permanent employees, and there was no right under the regulation to apply and or be considered. And in coming to that finding, they relied on the judgment of Justice Langstaff in the Coles Ministry of Defence 2016 case, which I'll explain now. So Mr. Justice Langstaff said in the Coles case, the directive provides a right to information. The purpose is to give temporary agency workers the same chance as other workers to find that permanent employment with that end user. It has nothing to say about the terms upon which there should be recruitment for that post. And if an employer wishes to give preference to those being redeployed, perhaps to satisfy his obligations to them as his permanent employees, he is entitled to do so. So that's the principle from the Court of Appeal as per Langstaff J. Question, was that going to win the argument in the Coker case? Well, when the Court of Appeal looked at Coker, and bearing in mind the decision that the same court had already made in the Coles case in 2016, it's perhaps not surprising how it played out, but we've got some important clarification here. First of all, in terms of the analysis, the starting point, as is often the case when it comes to arguments about regulations in UK law that have had their origins in European law, and by the way, Brexit has no, it was agreed in this entire case that Brexit had no effect as to whether or not the directive should have an interpretive quality in terms of UK regulations. That's an important point of interpretation. Article 6, Temporary Agency Workers Directive 2008, a literal reading of that and of Regulation 13.1 actually was very restrictive. So if you only looked at the literal wording of Regulation 13.1, then the literal reading would mean that the worker is only entitled to notification. So the follow-on question from the claimant's point of view is, okay, if the literal reading is very narrow, surely there's a purposive interpretation that's required to equate notification with a right to apply and be considered. And the argument in a nutshell is this: what's the point of being able to be notified of something if it doesn't have a practical reality on the back of it? In other words, okay, you can tell me that there's a job available, but if I can't apply for it and if I can't be considered, then what use is that right to me? But the Court of Appeal came down on the side of the narrow argument, and there are a couple of reasons for this. First of all, it's about striking the balance between competing interests. In other words, if a hirer, a third party that isn't actually employing the agency worker, because the agency worker is provided to that hirer by an agency through which the agency worker is employed, then you're going to have a situation where third parties are bound, as soon as they have agency workers, to treat those workers as if they were permanent members of staff when it comes to, in this particular case, potential jobs within the organisation, internal employment. And the Court of Appeal made the important point that when it comes to businesses, they have to be able to have the freedom to allow recruitment internally, particularly if that's a way of not increasing their headcount. So that economic decision, that business decision, we see this across employment law, don't we? Redundancy is a classic example. Tribunals must be careful not to venture into business decisions unless there is good reason to do so. Also, the Court of Appeal said, no, the interpretation rights, the narrow interpretation of the right to be notified is not meaningless, that there is value in being notified of internal recruitment and posts and vacancies in and of itself. Now, that makes me think, well, when was the last time that the Court of Appeal worked for an agency? Because with all due respect to the Lord Justices of Appeal, if you're an agency worker, really, is it valuable to be told that there are other vacancies available within an employer that you're not entitled to apply for? And I suppose that this is maybe where it's slightly artificial. On the one hand, you could say that the notification is valuable in and of itself. On the other hand, you'd say, well, what's the point if I can't apply for it? This is the example of where the striking the balance comes, I think, to bite really here. Because if the Court of Appeal had said, well, the right isn't just a narrow one, but is a broad one, it doesn't just mean the right to notification, it means the right to apply, and therefore the right to be considered. Because again, you might have the right to apply for a job, but it's pointless if it's not going to be considered. You could fire in an application form, but if the employer could just tear it up and not even read it, then the right is pointless, arguably. But if they'd gone down that argument, then the breadth of the directive right, which is what this all flows from, starts to become quite unwieldy, I would say. And that's why the Court of Appeal ultimately said there is nothing within Article 6 as our starting text that the European Commission, when formulating this right, had in mind the knock-on implications that an agency worker would have essentially the same right to apply for internally advertised posts as a permanent employee. And that was essentially to take it too far. So the narrow construction of Article 6 and Regulation 13.1 was deliberate and valid, and that the adverse impact could also not be underestimated. What about redundancy situations or redeployment situations? The employer would be under an obligation to consider redeployment for those permanent workers, or at least those of employees that would have potentially been caught in a redundancy situation. If then they had to compete with agency workers that were already in the mix, that would have a negative impact in terms of the business efficacy of that in-house process, considering that there are legal obligations on the employer in those sort of situations. I think that it's probably right that the agency worker, although it might seem harsh, is left out in the cold on that one. So there we are. That's COCA. Very quickly, because of time, I'm going to deal with the case of Byrne. This was from the end part of last year, running through the facts very quickly, but let me give you the headline. This is all about whether or not the implied terms of mutual trust and confidence act as a sort of vacuum cleaner and vacuum up any potential breaches of things that happen through disciplinary or grievance procedures leading up to dismissal, or whether or not there's a separate subset of an implied term when it comes to a fair process, when it comes to disciplinary and or grievances. But of course, alarm bells are going to be ringing, because Johnson exclusion zone is never far away as soon as we come close to that issue of dismissal. Anyway, let me run you through the facts very quickly. The claimant was a consultant pediatric neurosurgeon. She was on call during a period between the 1st and 4th of December 2017 when there was a child A was undergoing treatment at the hospital. A different surgeon, Dr. M, operated on A on the 3rd of December, and a few days later, sadly, A died. As you can imagine, there was a 360 review, what had happened, what had gone wrong, root cause analysis, etc. The shakedown of all of that was that the respondent in this case, because this was an injunction appeal through the High Court, was going to investigate the claimant and invited the claimant to participation in an investigation. Now, the claimant refused to engage in that investigation until she was provided with certain copies of documents that were in the possession of the respondent and had been cited as part of the investigation thus far. So the claimant went to the High Court asking for an injunction restraining the ongoing investigation to allow the disclosure of these certain documents and a declaration of rights. Skipping through this very quickly, the disclosure issue related to an express term within the policy. It was a contractual disciplinary policy Paragraph 1.16 of the policy said that the practitioner concerned must be made aware of the specific allegations or concerns that have been raised, given the opportunity to see any correspondence relating to the case, together with a list of the people that the case investigator will interview, and afforded the opportunity to put their view of events before the case investigator. It's that middle part, given the opportunity to see any correspondence relating to the case. There were other provisions, as you can imagine, as well, in terms of the policy, accompaniment, unbiased investigation, etc. So the claimant's case was in two parts, really. First of all, point one was that paragraph 1.16 was an express right that the claimant was entitled to see all of the documents seen by the case investigator in connection with the investigation. The case investigator had actually given the claimant a list of documents and types of documents. I think there were 22 in all, that the case investigator had already obtained. Some of those documents included statements that were taken as part of the root cause analysis, including statements from Dr. M, the doctor that had, or the surgeon that had operated on A day or two before A had passed away. Some of those documents had not been released to the claimant. That was the issue. But the second argument was, even if it's not an express right, this is point two on the slide, there's an implied term, the implied term of trust and confidence, that the claimant should be able to see at least the withheld documents in order to respond properly to the investigation. Now, the High Court rejected both of the claimant's arguments, and being LJ only permitted ground one, the express term, through to appeal. Now, running through that very briefly, the Court of Appeal rejected the argument that there was an express right to essentially broad disclosure at this stage. But what about the implied term? Underhill LJ in the Court of Appeal said, the claimant's core submission was that it would be impossible for the case investigator to perform their obligation to afford the practitioner the opportunity to forward their view of events, which must, of course, be a fair opportunity unless he or she was given access to the documents which will enable them to do so. She reminded us that the process is intended to look for exculpatory evidence as much as inculpatory evidence. So that was Underhill J's taking a summary of the claimant's position. And Underhill J said, it all comes down to a question of fairness. There may not be, on the orthodox view, a general implied duty on an employer to act fairly in all contexts, but such a term is very readily implied into the context of disciplinary processes. And he relied on the Chakrabarti case of Mrs. Justice Simler from 2014, where it was said that the practitioner must be given the opportunity to put their version of events necessarily implies that they must be shown all of the documents that they fairly need in order to be able to do so. What those documents are will obviously depend on the particular circumstances. So what Lord Justice Underhill was saying here is there is not a general disclosure obligation, whether or not in express or implied, but there is a fairness-based obligation, and that is very important. And that is something akin to an implied term. Going on, it's not necessarily a matter of fairness for claimant to be given the copies of the withheld documents before she is interviewed, but here are the obiter comments. I wish to add that I agree with Singh LJ's observations, which we'll come to in a moment, about the conceptual basis of the duty of procedural fairness to which I referred to above. My strong provisional view is that it is preferable to treat that duty as arising from the nature of the disciplinary process rather than an aspect of trust and confidence. Now let's pause, okay, because there's a lot of material there, and I'm conscious of time. But essentially what Lord Justice Underhill was saying, and Lord Justice Singh goes into a little bit more detail in a moment, is that if there is an implied term, it's an implied term of essentially procedural fairness. Now, bearing in mind, this is a High Court injunction case. This isn't a statutory right of unfair dismissal at this stage because the person hasn't been dismissed. This is about injunctive relief. But nevertheless, under the common law, an implied term of procedural fairness, and it doesn't just arise from the good old implied term of trust and confidence, but it arises, the Chakrabarti case says, from this discrete right of the disciplinary process itself, an implied term of fairness within that disciplinary process. Let's have a look at what Singh LJ says. There's no freestanding obligation to act fairly, which is separate from the term of trust and confidence. That's the point in Gregg and similar in Chakrabarti. Rather, where the authorities contemplate questions of fairness, rather than in a general sense, Rather, when they consider fairness, they do so in the context of the implied term of trust and confidence, or in the narrower basis of a reference to an implied term that disciplinary processes will be conducted fairly and without unjustified delay. So can you see what's happening here? If you consider the implied term of trust and confidence as a bit of a vacuum cleaner which soaks up or sucks up anything that could potentially be a breach of trust and confidence, I mean, an unfair disciplinary process you'd think would fall within that remit. But what the Lord Justices are suggesting, albeit in obiter here, that there might be a more discrete right, a narrower basis of reference that wouldn't just get sucked up by the implied term of trust and confidence. And it's that right, implied term, of a fair process. Now, this is building upon the idea of Braganza, where the common law wrote into, as an implied term, using public law doctrine, that discretion in a contractual discretion shouldn't be used in a malicious way or in an irrational way. Ideas of Wednesbury fairness from the public law sphere into private contracts. So quite a radical departure there. This is a small stepping stone on top of the idea of Braganza. And here it is. There's no general obligation of fairness, but procedural fairness, the second bullet point, there may be a narrow basis for an implied term that disciplinary processes will be conducted fairly, which is not conceptually linked to the implied term of trust and confidence. An important issue of principle open for future cases, making it very clear they weren't deciding it in this case. But it does not appear to me that there would be a legal impediment to such an implied term. So the question, is this positive judicial endorsement of a discrete implied term of procedural fairness in the disciplinary process? Singh LJ's view is yes. If the law were to employ a term into the contract of employment that disciplinary processes must be considered fairly, that would be a short step which builds on Braganza. Where does this hit the road? In short, injunctive relief. Injunctive relief is possible, according to this obiter comments from Lord Justice Singh, that where an employee or a worker is involved within an investigation process or a disciplinary process, and there are allegations, discrete allegations of unfairness within that, that potentially leaves the door open for an injunction to say, hang on, that unfairness, which is a breach of an implied right, needs to be righted by way of injunctive relief, whether that be release of documents, whether that be a cessation of the investigation until this unfairness is righted. That is a potential scope there for claimants to run with. It's going to be a big argument, and this is only obiter at the moment, but perhaps more than ever we're seeing a door slightly ajar for that sort of argument, which is distinct from an argument linked to the implied term of trust and confidence. So there we go. Interesting case, Burn Alder Hay. And finally, a little bit of lighter and easier comment to say. The EAT has at last got its own neutral citation, which will start from the beginning of January 2022. So that's just something to remember when you're citing your EAT judgments, that you've got to use the updated neutral citation. A lot of
typing anyway, doesn't it?
Yeah, it does. It does. And it looks nicer, I think, as well.
Yeah,
there we go. I think that's us for this morning.
Any questions? And whilst you do so, consider the very next slide after that, which is our next event. Of course. 16th of March, our 10th annual seminar at the Watershed. I know some of you already signed up to it, but there's still spaces left, both for the online section and also for the in-person attendance, should you wish to join us there.
It's going to be good to see people.
Yeah, there is. There's even going to be a signature cocktail. So please come along. It'd be great to see you all in March, particularly as it's no longer February. Absolutely. Any questions arising? Leave the chat thing open.
I think you might be able to open up the chat on yours, because I think you're linked into this, aren't you?
No, I'm not.
All right. I can't see. Maybe if I stop presenting.
Good idea.
There we are. I'll just open up the chat function. So obviously, as we're conscious of time, and we have gone over because we were slightly late to starting. So apologies for that again. Any questions that you have, most of you will have our email addresses, etc. Please do get in touch with us. We'd be very happy to pick up anything arising from today, as always. But other than that, do have a good rest of the day. Hope this has given you a good fill up at the start of the day on Monday to hit this week of work. So all the best. If there's nothing immediately arising, do get in touch with us if there's something that comes up later.
Thank you very much, everyone.